In the new criminal justice bill, the government is trying to get around a number of court rulings that have found mandatory minimum sentences to be unconstitutional. What they're doing is writing a provision that, if passed, will require judges in imposing a sentence, if they find that the mandatory minimum sentence of imprisonment is cruel and unusual punishment, to impose a shorter period of imprisonment, but still imprisonment, than the mandatory minimum for the person, essentially to compensate for the fact that the mandatory minimum is cruel and unusual punishment. And you might think this is a good thing, but a lot of the cases that have done the cruel and unusual punishment analysis have found that just prison, period, is cruel and unusual punishment. So the fact that it is just saying, well, you can have a little bit less jail, isn't really accomplishing what the Supreme Court of Canada has really criticized about mandatory minimums and their application to broad ranges of circumstances. And for the driving law people out there, this doesn't change any of the mandatory minimum periods of imprisonment for people who are convicted of driving offenses. All of those are not affected by this. So even though there are mandatory minimums for your subsequent offenses for impaired operation, you are not going to get the benefit of being able to argue that it's cruel and unusual punishment and get a lower term of imprisonment on the basis of the fact that this provision's been added, because they're specifically excluding impaired driving offenses.